Hey everyone, it's Joy Bertrand with the Athena in the Well podcast. I'm coming to you today from my living room that's a little bit in a shambles because we've had pets inside that are supposed to be outside and stuff due to the heat. So if it looks like it's a little chaotic behind me, all I can say is yes. I am videoing this because more and more I'm seeing that video seems to be the new standard. It is not something I'm crazy about. I actually find it really weird. But I want to make sure that we reach as many people as possible with important information. And so I'm going to start videoing these as much as I can, posting them to YouTube and then cross-posting to the other podcast sites. And the other thing is I've been thinking about how to really run this podcast and make it effective for my listeners, but also make sure it doesn't really run counter to what I'm trying to do during the day by practicing law and consulting on trials. So I'm going to make them shorter often and just little bites that you can think about. And then, of course, if you want to hear more, we can have more conversations about it, or you can contact me and I'd be happy to talk with you more in detail. And I want to make sure they're timely. And it's hard to make timely podcasts when you also have to spend the time then preparing a really lengthy podcast. So this one's just going to be a quickie, but it's going to be a quick tutorial on what happened in the Baldwin rush shooting dismissal. What I want more than anything for listeners to take away from this, and I don't think it'll be an issue for people who practice criminal law, but for those who are either just regular people or civil practitioners, I want to make real clear that what happened in the Rust shooting trial with Mr. Baldwin was not a technicality. This wasn't a rabbit that the defense counsel pulled out of their hat. What happened here is the prosecution team knew about evidence that could have, maybe possibly could have helped the defense. And that information was not given to the defense. They weren't put on notice about it. And the defense, from my understanding, kind of fell into the knowledge by accident. And that's really common with these kinds of violations, is that the burden is on the defense to tell the court, we're not receiving all the information that the state has that would help our case, but often you don't know what it is. The leading case in the jurisdiction that I practice in the most, the Ninth Circuit, is the Bundy case. And you'll remember that case was these ranchers who were in a fight with the government over the use of their land, and they took over a bird sanctuary or something. And in trial, it came out that there was information from other surveillance footage that could have helped the defense. And the Ninth Circuit found that to be such a serious violation that it dismissed the case with prejudice, just like happened here with Mr. Baldwin. So the leading case, that's what goes on in the Ninth Circuit. The case that you look at is a Supreme Court case that is referred to as the Brady case. And when you hear criminal defense lawyers talk about Brady information or Brady Giglio information, that's what they're talking about. Giglio is one of the cases that came after Brady that kind of refined the point. But for our purposes here, it's a Brady violation. And this isn't zigged when you should have zagged kind of thing. This is a constitutional due process violation because a defendant has the right to know what the evidence is and is not against him. So here, the defense found out that there was this additional information apparently about bullets that included, a box of bullets that included live rounds that somehow gets taken to the sheriff's office, and they book it in for evidence under a different case number. They specifically flag it as not being relevant to Mr. Baldwin's case, but to another case that's related to Mr. Baldwin's case. And somehow, and now Finn, our great big dog, is giving his 2 cents in the background. Hey, buddy. And somehow the defense finds out about this and brings it to the court's attention, I believe while the jury was deliberating, and says, hey, there's a box of ammunition with live rounds in it. And you remember the issue with Mr. Baldwin was that he fires this gun in the making of the movie. It has a live round in it, goes off, shoots someone, they die. So he's charged, I believe, with manslaughter. And I always thought the case was weird to begin with. Like, what was the knowledge he was supposed to have? He's on a movie set. And to have manslaughter, you have to act with reckless indifference. And here, I don't know what that could be, but I hadn't worked the case too closely. But we can talk about the Brady stuff. So the prosecution then did something really weird in the Brady hearing in the Baldwin case. One prosecutor quits right before the hearing on the Brady, in the middle of trial, quits. The other prosecutor calls herself to the stand and apparently puts herself under oath to testify about what happens. And she kind of dances around about who knew what when. And what's really important about a Brady violation is it doesn't matter if the prosecutor knows or not. It's really bad if the prosecutor knows and doesn't disclose. But the knowledge is attributed to the entire litigation team. So the investigators, those working on the case with the prosecutor. So if you have a case agent, for example, and one of his coworkers at the office knows something that isn't disclosed, or if the agents keep it to themselves, that counts. And the reason that this dismissal was with prejudice, that means they cannot bring the case again. The state, they are done. Mr. Baldwin is done dealing with these charges, is because it is such a serious violation. And the idea is that unless you have a harsh remedy for these kinds of violations, the prosecution will just kind of play fast and loose with Brady. The other thing to know about a Brady violation is that in many jurisdictions, this is also a potential ethics violation for the lawyer, the prosecutor involved. Arizona's rules are so strict that Brady and its requirements even continue past conviction. So after the fact, you get a conviction. After the fact, you find out that there was evidence that could have. It doesn't even have to show that it really would have made a difference, but that could have made a difference to the defense and the success of the defense. They have to bring that to the court's attention. They don't necessarily have to move to dismiss the case, but they have to put the defense on notice and they have to put the court on notice. Federally, the leading case of this is out of the District of Columbia, not the District of Columbia Circuit, the District of Columbia kind of local court. And the case is In re Kline, Kline. And there, the prosecutor knew about evidence that could have helped the defense, I believe in an armed robbery case. And they didn't disclose it. And the prosecutor's response to that was, I didn't think it was that big of a deal. I didn't think it was that important. I didn't disclose it because I didn't think it mattered. And usually, as a criminal defense lawyer, when I hear that, I'm like, well, then why didn't you just disclose it and let me make that decision? That's not for you to make. You want to always err on the side of disclosure when you're a prosecutor. And there, the DC court found that they weren't going to run up Kline for ethics violations because the law wasn't clear at the time about the ethical burden of a prosecutor. But they used that case to say, moving forward, prosecutors, take note. This isn't just a constitutional violation. This isn't just something that a court might knock out your evidence or knock out your entire case. This is so serious. Your license is on the line if you violate it. And I think courts have taken such a hardline stance on this for a couple of reasons. First, because the defense really doesn't know what they don't know. And second of all, because I think otherwise there's this temptation to just be like, well, that's the cost of doing business, right? Like, you'll see that with the exclusionary rule and precluding evidence, like you should have gotten a search warrant, but you didn't, but you probably would have found it anyway. On review, there's what's called harmless error for some of that kind of mistake. I'll say that in the most generous terms. And here they're like, you don't get that. It's not a mulligan. It's not just a mistake where maybe some evidence will be excluded. One remedy could have been, at least in Arizona, that the jury received what's called a Willets instruction, W-I-L-L, I think I-T-S, where the jury could have been told, there is evidence out there that the prosecution did not give to the defense, and you can presume that evidence would have helped the defense. And of course, A defense lawyer loves to have that because there's their closing argument. What else don't we know? You can start right now with the presumption that my guy didn't do it, which you should do anyway. But now we have this additional presumption that there's evidence out there that we weren't allowed to share with you. We weren't given the opportunity to share with you, and you run wild with what you think that is. So I wanted to just touch base on this, and I know there's been a lot going on in current events, and I'm trying to decide how much I want to address that or not, because I'm not an election lawyer, and I have a lot of really strong feelings about politics that I don't know are necessarily helpful when talking about trial practice. But I didn't want this discussion and the importance of Brady and the importance of courts enforcing Brady to get overlooked in the mire. So that's our quick little tutorial for today about Brady versus Maryland, about withheld evidence by the prosecution and what that can mean constitutionally for a defendant, why it's so serious. As a side note, the reason I'm going to be talking in some of these kind of mini, sorry, we also have a little baby puppy who's finding her voice, in these little mini podcasts is because, the fourth quadrant of the Athena system is master strategist. And you can't be a strategist if you don't know what the rules of engagement are. Part of strategy is knowing who has to follow rules, what the rules are, what the remedies are if they're broken. And that plans your entire trial. It also plans your approach to a case. If you know you're dealing with a prosecution office that has, I'll say kindly, Brady issues, you've got to be really aggressive. And I've actually had cases that after the fact, I really regretted not pushing the issue more. At the time, I didn't want to be rude. I didn't want to, cast aspersions on people. But looking back, I really should have pushed issues and forced them to at least say to a court what they have. One option for prosecutors is they can say to a court, hey, we have this information. Would you please look at it privately and let us know if we need to disclose it? That's totally fair. And then it's up to the judge to decide if it should be disclosed. But just sitting on it isn't cool. So that's why I'm talking about it. And here's an example of how this can affect your strategy so dramatically. I was consulting on a case in another jurisdiction with a wonderful lawyer who was relatively new to criminal law, and had the added layer of weirdness with it that it was a juvenile delinquency case. So there were a lot more issues about sealed records and who gets what when, because the case was staying in juvenile court. The lawyer came to me and said, I know one of the witnesses against my client has a prior armed robbery conviction or some type of assaultive felony conviction. I know they are because word on the street, my investigators talk to people, word on the street is that this is going on. It's driving me nuts. I can't seem to get the prosecutor's office to even respond to me. They're just kind of blowing me off. And I said, well, that's actually really serious. That's a Brady violation. And this young new lawyer said, what's that? So we had about a 30-minute tutorial on Brady, and I helped her write the Brady demand to the court and say, Judge, this is what I've heard from my investigators. I don't have a way to corroborate that because these records are sealed, but you know who does know? Them. And they need to turn this stuff over. That motion not only resulted in my client walking her client on the charges, but that entire prosecutor's office was required to attend I believe a full day of Brady training as a result of that motion. So these issues are not to be taken lightly. They can drastically change how you see your case and what to be watching for. And now we have Piglet also chiming in here. Welcome to a day in Joy's house. And this is just one of those little things that you have to have experience with, and I think a comfort level with to call out when you see it. And sorry, but Piglet is a little needy. But Piglet's very pro-Constitution, right, buddy? Yes. So please think about that when you're looking at your criminal matters and watching the news when you hear people talk about a Brady violation. This is no laughing matter. It's really serious because it implicates the fundamentals of our Constitution that you have a right to a fair trial, not just a trial. That's it for now. And talking about Brady, if you want to talk about it more, you can reach out to me at joy@joybertrandlaw.com, or just leave a note here, and I'll be happy to respond. And also, if you like this kind of content, let me know. I'm still new to this, and I have an active law practice, so I'm trying to budget or balance between the two, but I thought this information was too important to keep and to sit on. So thanks, have a great week, and I look forward to talking to you soon, as does Piglet. Thank you.